that, we will begin our oral argument on LB, mother of IC, a child, versus the Department of Children and Families. And I might say we use initials. You may proceed. We use initials in order to protect the identity of the minors involved. That's why these cases are styled in that fashion. Mrs. Zimmer?
Good morning, Your Honors. May it please the Court. First, I'd like to say it's a privilege to be here, and that this is the first time that I've had the privilege to argue before this Court, so my nervousness doesn't show too much.
We're not going to go any easier on you. Just
I knew you wouldn't, but I figured if I just state that, then...
Counsel, do you wish to reserve any time for rebuttal?
5 minutes.
Okay.
Okay. We have a simple issue here. The issue here mainly is that the fact that the judge in the lower court had terminated the jurisdiction prematurely and had not given my client her due process rights, and there was not proper notice that he was going to be terminating the case at that time.
You know what troubles me about that is that her attorney clearly had those, and apparently her attorney had a substitute attorney show up for the hearing, and the attorney that did show up essentially waived the error, didn't he? Yeah. What are we supposed to do with it?
Well, I was the attorney in the lower court.
You were the one who didn't show up.
I was the one that did not show up. What happened is that there was a hearing, and the dates are important here. There was a hearing on April 4th where there was a discussion regarding whether or not the case should be terminated or not, and I objected to that at that time. There was a judicial review that was previously scheduled for May 4th, which was the hearing where he did terminate. I had indicated that I was not going to be available at that time, and we pretty much decided it was just going to be a judicial review, and the judge in the lower court scheduled a hearing on June 2nd to discuss whether or not the case should be terminated at that time. I immediately filed a notice of unavailability 1 month prior to May 4th. The day after the April 4th hearing, I filed a notice of unavailability. And because I was under the idea that it was just going to be a judicial review and that nothing was going to happen and that all the decisions would be made in June. So I was under that reliance at the time. Had I known that...
Well, wait. Didn't you designate someone to take your place then?
I did. I asked an attorney to cover it for me. And I did not expect for him to make those decisions.
What are the limits of the attorney's authority to make that decision? I mean, I guess what's troubling me about this is that if the person is represented and that person fully represents the mother in this case, then what's wrong with the attorney agreeing to waive the later hearing?
Well, excuse me, to waive the June hearing?
Yeah.
Well, first of all, the mother herself was not there. I did not have the mother there because I was on the reliance that we were going to have a June 4th hearing.
Oh, so notice is not an issue?
I knew about the May 4th hearing.
I mean, notice to the mother is not an issue.
She knew about the May 4th 6 months prior because the rules of the dependency is that you schedule a judicial review 6 months from the time of the shelter. So that was a date that was required by law. There was a discussion even at that April 4th hearing, should we have the May 4th judicial review or not, and the attorney for the department said, well, we're required by law to have a judicial review every 6 months. So the understanding was that the mother was going to attend the June 4th hearing. And so I don't think that the attorney that was there on my behalf really had an opportunity to speak to the mother or to even locate her to have her come to that hearing where she would be able to properly defend herself at that hearing. I had asked him, judicial reviews typically are administrative, where they review, where have they gone from the task in the case plan, and usually we know when important decisions are going to be made to judicial reviews. Most of the time they're just administrative. making sure that everything is on target. And that was my understanding, that all decisions by the court were going to be made at the June 4th hearing. When I saw the transcript, I didn't have the privilege of being, or the benefit of being there. It wasn't until I read the transcript after I ordered it. I immediately ordered it, and when I filed the notice of appeal and read the transcript and saw what he said, I did not give him any indication that that was something that was going to be discussed at that hearing.
Well, does the trial judge have the inherent authority to come to the conclusion regarding termination at any hearing?
To close the case? At the judicial review, he is allowed to look to see whether it would be impossible for the mother to complete her task on time. If he feels that if she could not, if the mother had not, she should be given every benefit, but that at the time, if he felt that she could not complete her task, then he could close the case. But it was 6 months. She had plenty of time. If she had decided to, come forward and start beginning her task, she could complete the task within the 1 year required time.
Is that a discretionary call on the part of the court?
Well, you have to show that she is not in substantial completion of the case plan, and that there's no probability that she will ever be able to complete the case plan. And that's one of the issues that is shown when you review the transcript, that he did not find that she was not in substantial compliance with the case plan.
Counsel, is the trial judge obligated to use a case plan initially before the final decision is made? Is there any law that says, or case that says that the trial judge must use a case plan approach before?
Yes, there is. The parent is provided 12 months in order to complete the case plan. If the department or any party believes that she is unable or not willing to complete, then you have to file a motion to modify the case plan and to change the goal of the case plan. Here, the case plan was reunification within 1 year. And
what if the trial judge, though, simply concludes that a case plan, which is a plan where the mother has to do certain things and work with certain agencies and those sort of things to rehabilitate herself, what if the trial judge concludes that that's just a waste of time, it's not going to do any good? Doesn't the trial judge have the inherent authority at that point to simply terminate?
Well, it has to be an evidentiary hearing. There has to be evidence to show why that she is not completing the case plan. That he can't arbitrarily decide. It's because when a parent, at the disposition stage in the beginning of the dependency, the judge accepts the case plan, it becomes a contract between the department and the parent that with a ends in mind that there will be reunification, and the parent relies on that case plan similar to a contract, and should be allowed that 1 year to work on towards the case plan. In this case, the reason that I find it difficult is that this was a newborn child. The child was 2 months old when she was removed. The mother became homeless as a result of the dependency, and so there were difficult times for her. So in dependency, you have to look at each individual situation. We were not talking about a parent with teenagers or things like that. We're talking about a mother, a new mother, who had her child taken away from her very early and was, pretty much thrown out of the house without any support at all from the father.
Well, the biological father is the person who currently has custody of the child.
Yes. But she should be afforded the opportunity. That was my second issue in my appeal, and that was the issue that I was going to argue on June 4th, that she should be given the opportunity to complete her case plan. This honorable court decided in last June 2005 in DS versus DCF, which I wrote the opinion, was that the mother is entitled to have that 1 year to complete the case plan, and that the court, if you're going to change the case plan, if you're going to change the goal to give the child to the father or long-term relative placement, then you have to change the case plan. There has to be an evidentiary hearing. There has to be an opportunity, due process. It's a very simple concept. It's a due process.
Is it your argument that there has to be a hearing on whether she's complied with the case plan? Correct. Or initially whether or not custody should be?
No, whether she's complied with the case plan. And that was not planned for the May 4th hearing. He had never really decided whether or not she was in substantial compliance with the case plan, although she had not done the test. I mean, he could have simply had an evidentiary hearing to show that she was not in compliance, but
Was any evidence presented at all concerning whether she was in compliance with the case?
I have the transcript here. It was just pretty much just decided to close the case. It was a very short hearing.
Well, but it was with the consent of the attorney, right?
The attorney who was there on my behalf.
Whatever, it was her
Yeah, it was. He was not representing her. There was no substitution of counsel. I had filed a notice.
No. He appeared and
He appeared on behalf of the mother.
And that appearance constitutes determination that he is her lawyer at that point.
But had I been prepared, had I known that those issues were going to be discussed at that time, I certainly would have prepared him for that hearing. Maybe what he should have said was, I'm not prepared to address this issue.
What he should have said is, I disagree.
Yeah, right.
Or ask for a continuance or whatever, but I mean, that's...
Then we're looking at an ineffective assistance of counsel, which I don't want to go there. It's just that I had told him...
Wait a minute. Ineffective assistance of counsel is in a criminal law context. Are you suggesting that it's also available as an argument to use in juvenile cases?
I might have misspoke. That may be true. It may not be true. I'm not sure at this time. But my point is that he was not representing the mother in her best interest at that hearing, because he was not familiar with the file and did not understand that there was a hearing already scheduled by the same lower court judge. What I don't understand is why not just wait for the June 4th hearing and to adhere to the procedural due process rights that she has, which is a fundamental right, that she should have the opportunity to address the issues at the June hearing.
Well, as I read that transcript, what sort of happened was there was a general discussion about the progress that the mother was making, and the trial judge sort of opined, I really ought to just close this case now, and turned to the lawyer and said, what do you think? And he said, yeah, I don't see any reason not to, and I wouldn't object. I mean, I'm trying to figure out how we would craft a rule that would accommodate your client in those circumstances. If she's represented by a lawyer, he's speaking for her. She had notice of the hearing. She did not appear for whatever reason, chose not to, or was unable to. He gives up her rights. Now, maybe that's a grievable offense or something to the Florida bar. I'm trying to figure out how it affects our decision and what we can do with that. And I'm not sure that I know the answer to that.
Well, I'm not sure if that's something that, if it were the attorney that was of record, if it was me, and if I were to still have the right to appeal that decision, have the appellate right to, review the file and to come back and file a notice of appeal. I would think that the mother, that she has a right to be heard, and that the fact that there was a hearing scheduled on that issue, on that specific issue was already scheduled, and that issue should not have been addressed. And I guess the hurdle of having someone there who is unfamiliar with the case, it's certainly a hurdle to overcome. But the facts remain that it was unfortunate that issue was addressed on the date.
You understand that the role of the appellate court is to correct any errors that were made below, and you're contending that the error was in closing this case. But wasn't that error invited by an attorney who represented this woman at that particular time? Wasn't that an invited error?
I think he agreed. I think he may have agreed, but it wasn't. He was not the one that initiated saying, let's close this case.
Well, but when the judge says, don't you think and he didn't object, he says that's a good idea. I can't remember the exact language, but it seems to me that he's inviting the error, if there was an error, by suggesting to the trial court, yeah, this thing can be closed.
If that is true, but that is the case. But in any event, I guess he was just not in a position. I guess my main argument is that we had relied on the fact that this particular issue. Now, to bring that whole subject up of closing the case at the judicial review is a due process issue. We were not given adequate notice that that issue was even going to be addressed.
I thought there was continuing. Isn't there continuing jurisdiction on the part of the trial court to close the case at any time?
Yes, but upon a hearing, in these type of cases, there should be an evidentiary hearing, especially if...
Not if it's waived.
No.
Did you go back to I believe it was Judge Hauser, and explain the situation to him, file a motion for rehearing, anything like that, and just explain to him what happened, and just ask him to reconsider his ruling?
No.
Why didn't you do that?
Well, I found out about the hearing later, and that was an option that I should have thought about maybe after the fact. It was after the time for a motion for rehearing when I decided to take this forward, because I felt that the mother should always be given the benefit of the doubt when her rights as a parent are being taken away, and that she should be given an opportunity. So, as an advocate for her, I believe that there was a due process violation in not allowing us to argue that at the June 4th hearing.
So if I understand, basically you're saying that you had no advance notice that this particular issue was going to arise at that particular time, neither did the mother. Substitute counsel was unfamiliar with the case, and then essentially made the agreement with the trial judge for closure, and that's basically what happened. And you're saying that is just not fair, and it deprived your client of due process because she didn't know, you didn't know, and she's entitled to at least a hearing.
Correct.
Counsel, your time's you got 4 minutes left to rebut.
Thank you.
Counsel, give me just a second here to reset this. Okay, you may begin.
Thank you, Chief Justice, and may it please the Court. My name is Angela Fortier, and I represent the Guardian Ad Litem program in the best interest of the minor child I see in this matter. Mr. Peters represents the Department of Children and Families and has requested 2 minutes.
If we're going to talk about the best interest of the child, why wouldn't it be in the best interest of the child to allow the mother to have an opportunity for a hearing and to present her side as to whether there was compliance and all the other issues that would have been decided at the hearing that was, I think, was scheduled for, when was that? It was June 2nd. I mean, if we're going to talk about the best interest of the child, as you just alluded to, why wouldn't that be the best thing for everyone concerned here?
Well, Your Honor, at the May 4th hearing, it is a judicial review, which at any point the trial judge has the ability to close the case if he finds that the child has obtained permanency. At that point, the Guardian Ad Litem program's position is that that child had obtained permanency with the non-offending biological father, which is what happened in this case. Therefore, there was no need for the June hearing, which was actually scheduled for June 20th.
Well, how does the trial judge know that it's the best interest of the child unless he hears from the mother?
Well, Your Honor, the mother had full notice of the hearing.
Well, she knew there was going to be a hearing, but according to opposing counsel, she didn't know that, this particular matter was going to be brought up at that time, and she didn't go to the hearing. And the trial judge just kind of brought it up, asked a question, and obviously her substitute counsel agreed. But she may have had notice of the hearing, but really the mother didn't have notice that was going to be, the issue to be resolved at that particular time, did she?
Yes, Your Honor, I do believe that she did have.
She knew that the issue of closure was going to be discussed at that time, at that hearing.
Yes, Your Honor. Dealing with a judicial review, it is not simply an administrative hearing. At a judicial review, you do discuss the permanency of a minor child, and that is found in Florida Statutes Chapter 39, as well as the Florida Rules of Juvenile Procedure. Permanency would also include terminating the court's supervision and jurisdiction.
No, but she wasn't given explicit notice that this issue is going to be decided at this particular time. It was basically a judicial review hearing where a lot of different things can be discussed, and she really didn't know that it was going to be terminated at that time, did she, or closed at that time?
Yes, Your Honor, I do believe that she did.
Then?
the Department of Children and Families filed a motion to close the case on April 4th, 2006, which was according to the Florida Rules of Juvenile Procedure 8.345. She was very well aware back in April that that would be the intent of the department, as well as within the judicial review status report that was filed by the department prior to the May 4th hearing. In respect and for the purpose of the May 4th hearing, it stated in there that the department...
Was the motion noticed for hearing at any particular time?
No, Your Honor, it was not specifically motioned for the hearing.
All right.
Counsel, were you the guardian ad litem below?
Yes, Your Honor, I was.
Did you make a recommendation to the trial judge as to the disposition or closing of this case?
Yes, Your Honor, I did within my guardian ad litem's report and recommendation to the court. I did. My belief, and through the investigations that I performed, was that the child had reached permanency, and it was in that child's best interest to remain with the non-offending biological father, who had in fact been the actual responsible parent for that child since the child was first born.
Did you go into an explanation with the trial judge as to why you felt it was in the best interest of the child, what facts you found from your investigation?
I did within that report, Your Honor. Yes, I did.
What did you tell her?
Pardon?
What did you tell the trial judge?
That I believed it was in the best interest of the child.
Why? Why?
That the mother had not complied with even one of the 7 tasks of her case plan, that I had myself filed a motion to amend the case plan back in March that was noticed for hearing on the April 4th hearing, in which the court did find and did amend the case plan to require the mother to submit to a drug and alcohol assessment due to the mother's recent incarceration for prostitution as well as the possession of drug paraphernalia. At that point, the judge agreed with me and, in fact, did amend the case plan to add that task. The mother had not complied with even one of the 7 tasks. Also, the trial court did hear from the father, the biological father, who was taking care of that minor child at the May 4th hearing. The court heard from that father that he stated the mother had been to visit with the minor child only once within a 7-month period, and at that visit, the mother continued to physically abuse the child. She would simply throw the child onto the couch. The minor...
Got it. So your report indicated to the judge that your investigation revealed that the mother was a prostitute, an alcoholic, and she abused the child?
Those were some of the information that was included within my report, but it was also included within my motion to amend the case.
And she failed to comply with the case plan?
Yes, she had failed to comply with the case plan. As well as that the father was actually, he was a parent who was taking very good care of that minor child. He had the child enrolled in daycare. He would pick the child up from daycare. He was there when we would visit with the child over the month period. He was appropriately caring for the child. The child and he had a bond that was together. The child acted appropriately. She was fed appropriately, clothed appropriately. She had a bond with that biological father. She did not have a bond with that mother, to my knowledge, because I was not aware of or had not had the ability to view the mother visiting with that child, because she had only visited with the minor child once within the 7-month period that we were appointed. That visit was supervised by the biological father.
You know, I guess the difficult thing about this case is that if the judge had simply waited a month and had done exactly the same thing, we wouldn't be here. What was the hurry?
Well, Your Honor, I do not believe that that is actually the mother's argument as well. She argues that it required 12 months. The 12-month, the case plan actually expired on August, but the trial court had the ability to close the case at the judicial review hearing of the May 4th hearing because, as this court had previously stated, all of the parties did agree. There was proper notice. The parties agreed. There was no objection whatsoever. And, in fact, my first argument is that this is not an appealable issue.
What would it be? You said that the motion was filed prior to the hearing, but the motion was never set for hearing. I mean, the motion was just filed. And so opposing counsel knows that the motion is out there. It's been filed. It's never been scheduled for hearing. And she doesn't come, and so she has a substitute counsel appear for her, probably thinking that, well, they haven't scheduled this for hearing, it's not going to be heard at that particular time. And shows up, and I understand the fact that the substitute counsel agreed, waiver, call it whatever you like. I mean, that's a problem, but it just seems to me that it may be a bit unfair in this particular circumstance to have that motion out there that they're aware of. They know it's never been scheduled for hearing, then all of a sudden was adjudicated based on one question from the trial judge?
Well, Your Honor, I do believe that the mother still had notice even prior to it, regardless of whether an official notice of hearing was filed in regards to the motion to close the case. In the judicial review status report that was filed with the court, and a certificate of service states that it was obtained or at least mailed to the mother's attorney in that case. It does state in there the department's position and request to close the case as well. And that judicial review status report was specifically created for the May 4th hearing. Initially, Your Honor, I believe that appellate review is precluded. The Ninth Judicial Circuit Court Judge James Hauser was correct in finding permanency in the placement of IC with her biological, non-offending father. After determining that the mother had not substantially complied, not even made a good faith effort by not even complying with one of the 7 tasks, in which she was well aware of the case plan. There was a case plan conference that was held back in October. The minor child was first removed in August and immediately placed back with the non-offending biological father with the requirement that the mother could not remain in the home. That is, in fact, what happened. The mother was aware and her attorney was present at the case plan conference in October, wherein the case plan was created. There were 6 tasks initially that were created. And the case plan goal was not only reunification, but the case plan goal was also to maintain and strengthen the family placement with the father. Therefore, the mother had complete notice that the case plan goal, there were 2. The mother failed to even put forth a good faith effort within the case plan in order for her to have reunification with the child. And the guardian ad litem program's position is that the child is in the child's best interest to remain with the non-offending biological father.
Thank you.
That's what as part of that guardian ad litem program, you serve without compensation, don't you?
Your Honor, I'm actually a staff attorney with them.
You're the staff attorney with them, but there are guardian ad litem volunteers that serve without compensation, aren't there, that you
Yes.
supervise?
Yes, there are, Your Honor.
Okay. And there's numerous such individuals that are serving in the juvenile justice system, aren't there?
Yes, there are, Your Honor.
I just wanted to mention that for the veterans that are here, so that they know that the bar is providing a real service here, because the guardian ad litems are supposed to be neutral, and they evaluate the facts in the case and then make recommendations to the trial court. And for the most part, they do it without compensation for the good of the system. Thank you, counsel.
We do appreciate that. As well, if I may mention also, the mother relied on the case law DS versus the Department of Children and Family Services. That was a 2005 decision. That case is distinguishable from this case that we have in this instance. In DS versus DCF, the mother had made a good faith effort to work on her case plan, and in fact, the general magistrate in that hearing had found that the mother had substantially complied with her case plan. In this case, that did not happen. The court found that she did not substantially comply. In fact, had not completed one of the 7 tasks.
Did he actually make that finding?
Your Honor, what he stated according to the transcript is that the mother has done this.
Yeah, but he's not made a written finding that she's failed to comply with the case plan. I mean, he couldn't, because you didn't have an evidentiary hearing, right?
No, Your Honor, because the evidentiary hearing was waived. They were in agreement.
Thank you, counsel.
Mr. Peters, I think, has a...
I'm sorry, Mr. Peters,
So I just wanted to make a few statements and answer any questions that you have. As was noted here,
And you're representing the Department of Children and Families as opposed to your co-counsel, who is a guardian ad litem, correct?
That's correct. We have a disagreement. Most of the time we are on the same side. As was noted earlier, there's no indication that there was going to be any hearing on terminating the department's supervision and jurisdiction of the case at the judicial review.
This was simply termination of the case. It was not a termination of parental rights case, was it?
No, it was just jurisdiction of the trial court, leaving the child in the permanent custody of the mother. I think a better way to look at the attorney, and I understand what the court is saying about this gentleman, is that he was more of a caretaker attorney who appeared as a courtesy for information to relay from Ms. Zimmerman to the trial court, should the trial court have any questions concerning the status of the child, status of the case. I don't think he was there to make substantial decisions on the case, and I say that because the first time he speaks in the transcript, it's in reference to the mother's appearances with Ms. Zimmerman, talking to Ms. Zimmerman, and he said Ms. Zimmerman, or words to that effect, has had no recent contact, words to that effect.
Are you saying that the waiver was ineffectual?
Yes, sir.
All right, and so if the waiver was ineffectual, then what you're saying is that there should be a hearing.
Yes.
Well, how do we distinguish between when a lawyer has authority to speak for his client and when he doesn't?
Well, as I said,
that's the troubling part about that.
I think he was a caretaker attorney, but also I would note that Ms. Zimmerman had filed a notice of unavailability. So I think this attorney was acting as a caretaker to provide information to the trial court and not there to make any substantive decisions, because after he makes that first statement that Ms. Zimmerman has not had recent contact with the mother, the rest of the time he makes statements, he does it in the first person.
You said you're on the same side with counsel for the guardian ad litem. You're essentially saying that you're on opposite sides.
I have conceded error.
Okay.
And the other things I wanted to mention.
What do you suggest the court do then?
I think she's entitled to a hearing. There was no competent, substantial evidence concerning noncompliance. What the judge was going on was the status report from the guardian ad litem and a judicial review report.
If you concede error and you believe that this case ought to be remanded for a hearing, why are we here for oral argument? Why can't you just stipulate to that and get it over with?
Well, I conceded error. I did not request oral argument. That was the guardian ad litem. But I figured I should make an appearance in case this court had any questions. Other things I wanted to bring out, there was a 12-month case plan. 12 months didn't go by. Invited error doesn't really apply. There was a decision.
You know, I'm going to ask the opposing counsel again. I'm still a little bit confused about why should we go back to Judge Hauser and just explain the situation to him. In all probability, I mean, we wouldn't be here today and we would have had a hearing, but I think she said maybe the time limit had expired for filing a motion. Do you know, is that what happened, or?
No, sir, I don't have any information.
Enlighten me on that.
Invited error wouldn't apply in this particular case. This court, on bank, issued an opinion either last week or the week before, or no, it was maybe Judge Evander. Thank you. Issued an opinion saying that on an adjudication of dependency where a decision was made by the trial court based on the proffers of the attorneys, that invited error was not something that should be applied to dependency kind of cases, especially in that situation. I would say that that's analogous here. If there are no further questions.
Did you file a brief?
Yes.
And in your brief, did you concede error and suggest that this case ought to be remanded?
I conceded error. I don't know that I said it should be remanded, but that's what I intended. No further questions. Thank you.
Why did you file a motion for rehearing? I'm still not clear on your answer. If you could come up and... okay, but I thought you said maybe there was some... So the 10 days had run? All right.
And I had probably seen gotten a copy of the order maybe 5 or 6 days later and thought about it for a few days. And maybe I could have even talked to Judge Hauser after the 10 days. And in
Counsel,
that probably would have been.
Counsel, you've gotten opposing counsel to concede error and suggesting that we ought to do exactly what you're asking for. So why?
Well, I just want to make one point.
I think he's probably telling quit while you're ahead.
You can talk yourself out of it.
You can talk yourself out of this if you'd like.
No, I was just going to say that what she said was the testimony that should have been given at that hearing.
Thank you, counsel. That'll conclude our oral argument. And,